First off, welcome everyone. I know everybody's busy, has a tight schedule. We'll stay on target here on our timetable, but we do appreciate you coming this morning. If nothing else, you have a wonderful breakfast, so hopefully you'll leave with some points of interest. Our agenda today is going to be talking really about intellectual property. And I thought maybe, first of all, my name is Bob Fesnak, Partner of Fesnak and Associates. I'm going to be the moderator today. Before I introduce the panelists, what I thought I'd do is take 2 or 3 minutes and just kind of go through why we think today's seminar is appropriate. In today's environment, intellectual property is by far the biggest asset of any company that any company owns, whether you're a capital-intensive manufacturer, or you're an IT, or a life science, or a consumer product company. If you look at the Fortune 500 companies, intellectual property or intangible assets represents about 80% of their market cap. So clearly, it's an asset that people should focus on. The way we look at it is, it's an asset and a group of assets actually that you want to be able to protect, optimize, and monetize. And that comes down to how good your IP strategy is. What is intellectual property? Most people think intellectual property is limited to patents and maybe trademarks. But to be honest, it covers a large assortment of things that covers 2 pages of intellectual property. And actually there's a list of these out front when you leave if you want to take one, but it may jog your memory when you're looking at your business and what intellectual property you want to be able to protect, optimize, and monetize. And so it covers, from customer lists, customer base, databases, trade secrets, which a lot of people fail to necessarily take care of sometimes. So it covers a whole range of things, and it covers all aspects of the business, from HR to marketing, through trademarks, to patents, through manufacturing and R&D. So, from that standpoint, it becomes a very complex legal and valuation issue because it covers such a broad part of everybody's business. We're blessed to have very good panelists today. I'll introduce them in a second, but what we want to try to cover is how do you leverage that intellectual property? How do you make it a competitive advantage for companies in today's environment? And so, with that said, these 3 gentlemen will be kind enough to kind of tell us, I think today, how to implement your IP strategy and how to leverage your IP. So, starting off at the far end, we have Doug Panzer. We have, in the middle, we have Drew Keese. And we have Rich Fagan to my right. And I'm going to let each one take 2 minutes to just kind of give their background, their experience, and what you're currently doing today. Go ahead, Doug.
All right. Thank you. My name's Doug Panzer. I am an intellectual property attorney with Fitzpatrick, Lentz & Buba. I'm a former software developer, and I spent about 8 years as a professional software developer, and then moved into the practice of intellectual property law, where I've worked on a large amount of litigation, transactional work, specifically in any technology area, but specifically in the software world, and intellectual property strategy, particularly figuring out the competitive intellectual property landscape between client companies and their competition, and then mapping out where the peaks and valleys are in that intellectual property space and working the business roadmap into that space.
Drew.
Hey, I'm Drew. I was part of a team with eCount that sold a business to Citi in 2007 and had some peaks and valleys with IP that I'll talk about today. And am now launching an investment firm. Have already launched. We are raising money, but have started it with our own capital. A little bit of a niche is that we don't just invest money, we invest our time, so we embed ourselves on the teams that we're investing in.
Hi, I'm Rich Fagan. Before I tell you a little bit background, and since it's Halloween, I'll tell you a little story. My wife asked me, where are you going? I said, well, I'm going to participate on this panel. And she said, well, what are you going to go as? And I said, well, I'm going to put on my suit and I'm going to try and look and sound like a business person that has a clue what he's talking about. She said good luck with that. I'm Rich Fagan. My background's a little different, complementary, hopefully, to my colleagues up here. I have a finance background, accounting degree, came out and worked with a lot of different companies. I started out in oil industry, worked in corporate aviation, spent 10 years in pulp and paper, consumer products company. Then I was with a specialty chemical company for about 5.5 years. And then I spent almost 9 years as CFO of a company called InterDigital Communications, which does a lot of wireless intellectual property, a lot of patent licensing, creating knowledge, patents, and monetizing them. Left there and got sucked back in the VC community to a software company, software as a service company, for about 1.5 years. I was CFO of a software as a service company called Starsight, which was bought by another company. Then started my own firm with another colleague, Intellectual Value Creation Services, and our major client was a private equity company out of London that was buying patent portfolios and needed help monetizing them. So we spent most of our time trying to help them license some of those portfolios or sell some of those assets. And then more recently, reformed a business. My former partner went out and got a job on the West Coast, and now I've teamed up with another former colleague who had a boutique investment bank that actually worked for me at InterDigital, and we do strategic advisory services to lots of different clients, some of which involve intellectual property, some of which involve just helping people think through their strategy, implementing what they want to do, and executing.
Excellent, thank you. So we're going to start off with our questions. This will be for the whole panel. Rich, maybe you can start with it, but each of you, Drew and Rich, have exited and sold businesses. Doug, you have worked with clients who have sold and exited businesses. Rich, what type of IP were generally in these companies, and also, how important was the IP in the business at the exit?
Well, I'll start out with InterDigital, which actually wasn't an exit, but InterDigital, for those of you who don't know, is a wireless technology company. Think of it, you've all heard of Qualcomm. Think of InterDigital of Qualcomm, but not selling chips. Okay, so InterDigital develops technology, tests the technology, proves the technology, but then creates a lot of patents. And the way it monetizes things is by licensing the patents. So our whole business model was built around creating the knowledge and the patents in order to monetize them. So it's very critical that you think about your know-how and really understand what, in that case it was patents, but even then you were always thinking about, all right, what are we doing? Are we patenting, or are we just creating know-how? Everything about IP was important in that business. And then I've worked with PE firms that are springing up now. You probably have heard of patent trolls that are buying a lot of intellectual property. So a lot of you may say, well, why should I care? Well, you may have stranded assets. You may be creating knowledge that you can't monetize. Well, these type of companies are looking for those assets and either sharing in the benefits of them or just buying them outright. So those are some of the things I've been involved in.
And Rich, at InterDigital, how many just to give the audience a perspective of the magnitude of the IP, how many patents and royalty streams were there?
Patents were in the 10 to 20,000
Right.
patents worldwide.
Right.
And our royalty streams were basically most of the handset providers. So I negotiated with teams with all the major handset providers, so be it Nokia, Samsung, LG, all the others. Okay. So these are very large dollars that we're talking about that created opportunities for ongoing recurring revenue streams. But we'll talk about it later, but you have to be willing to litigate in that type of environment.
Yeah, protect your asset. Drew,
So I would say I have two distinct kind of eras of my IP life. One is as an entrepreneur, and then one is running a global business for Citi that we expanded into 40 different countries that I ran. On the eCount side, when we were starting the business, growing the business, I think IP was always maybe 10th on a list of 100 things, and we could only ever get to 5, the top 5 things. I will say that there are probably 2 places where we distinctly leaned on it a lot in the kind of entrepreneurial world. One was we did have a patent for a type of payment, really a digital payment that went from one account holder to another. It's almost like an e-greeting card. But we leveraged that a lot in the sales process just to say we had a patent. But we never talked about it in detail. We just said our product is both patent pending and then, post being issued, we had and secured a patent. It just made us sound big, made us sound like we were protected, but I would say 90% of what we sold probably wasn't covered by that patent. But it was a good soundbite within the sales pitch, and we were pitching Fortune 500 companies, and any little edge you could get to make yourself seem credible as a small company was a good thing. The second was just the name eCount. We sold prepaid plastic cards, and we put it on every one of our cards, so our brand was next to Ford, GM, Dell, Toyota, even Ralph Lauren. So it was very important to us that our brand kind of went out in the market. And it wasn't important from a consumer point of view, but it was important from the businesses that saw it and said, hey, I'd like one of those cards, because we send payments on behalf of businesses. So we had a few disputes around a name with a Canadian company that slowed us down or distracted us. But from that standpoint, it was very tactical. It was very only when we needed it, only when the attorney could bend our arm far enough that says, like, you guys have to do something here, that we really followed through on it. After being acquired by Citi, two things really happened. One is it became not my issue. So a patent attorney would call me and say, here's, let's talk about your IP, or I guess an IP attorney really is a lot more than patents. And we would talk about what I was in charge of protecting, maintaining, owning, where there were issues with our product. So if I thought there were any risks of current IP in the market that Citi might be infringing on. And then secondly, at times we talked about being aggressive with the one patent we had. There's people infringing on it today. But Citi, we never wanted to fight. We thought about pushing and litigating a little bit and kind of making it a revenue stream and even outsourcing it to someone to do. But at the end of the day, we thought it was more of a distraction. On the Citi side, they definitely took just a defensive stance on kind of all their IP. And they said, hey, when someone comes to us, we'll show them our whole library and hopefully that'll make them go away. But they would not take an aggressive stance, which I was a little bit disappointed because they have a lot bigger pockets, and then it's a lot easier for Citi to go out and litigate. And I thought we had some great cases where people were really monetizing what we had. So those are kind of two distinct views, I think. One is very passive, and the other one was very tactical. I'll probably, in some other of the questions, I'll get into where IP literally changed our business and almost bankrupt us. But I'll save that.
That's
stuff
for the war
later.
stories. But
Yeah.
Doug, your client base, as far as how important IP is, do they, in your opinion, understand the importance of IP today and the value it brings?
I think that people definitely understand that IP is important to them. Whether they have really looked into the full range of things is an open question. I think that Rich and Drew's answers both really illustrate that there's this wide range of IP that people may or may not be aware of, and there's also different approaches depending on the industry, depending on your business model, your business strategy. So, like you said in your introductory comments, we always think of patents, but do people think about trademarks and copyrights and trade secrets? And Drew, what you were saying is very relevant to the trademark and branding portion of the, the big four, the patents, trademarks, copyrights, trade secrets. So, the interdigital story is, I mean, that's a model story of the power of an intellectual property portfolio made from patent holdings. But, if we look at companies like Google, they have relatively few patents, but their one biggest asset is a trade secret. It is the Google search algorithm. And you will never see a patent on the Google search algorithm, because in order to get a patent, you would have to tell the world how to do it. So, it really depends from industry to industry, and I think that everybody could probably benefit from looking now and again at how much or how wide they're covering their IP. But people are definitely aware of it, for sure.
And that's a good point on the Google example on the trade secret. I mean, we're seeing more and more clients who are asking, should we patent something, especially in technology, where your economic life is very, very short compared to the legal life of that patent, if you had one. And so what they're going is more to a trade secret, protecting it that way through confidentiality agreements, non-disclosures, sign in when you come in the front door as a guest, giving you a badge, taking steps to protect that IP, because they feel that'll last longer than if they had a patent where people can re-engineer very quickly, get their own patent, and it functionally works the same way as your product. And all of a sudden now you got competition, because the end user doesn't care what's behind the black box. They just want to know that it functionally works the same way. And so a lot of our clients are looking at that, weighing it. Biotech's different. You need the patent, but on some of the tech, it's just the economic life is so fast and people can re-engineer so easily. There's that question now. So you're absolutely right. Rich, for IP strategy, at what, in your opinion, with consulting with companies, at what stage do companies generally put in an IP strategy or think about implementing and putting one together?
Well, I think Doug's comments were very telling. We see, a number of companies who say, yeah, I really should be doing something, but it's 10th on the list and I only have X dollars, so I'm not going to pursue it. And what I tell them is, okay, there's a risk for you not doing that, because I've seen a number of companies where, whether it's trademarks, whether it's patents, etc., where they're running out of money, and guess what? That's what's going to end up getting money at the end, because that's the last thing standing, your know-how, your trademarks, your patents, and that's what people will pay for. And I always give them an example of, InterDigital, we were always looking for patents. Well, we bought some patents from a company that was in the Wi-Fi space. Well, they wanted to make chips, and that technology is turning so fast. And if you weren't one of the big players, and reinventing your chips every, 12 to 24 months, you couldn't play. Well, they finally realized they couldn't play in that, but they had some very good patents that we ended up paying them $10 million for. Well, that $10 million turned into about $200 million in licensing for the company. But the VCs were happy because they got their money out. Right? So a lot of times people won't take what needs to be done. I've got a couple clients now and I'm trying to push them into just getting trademarks. And, they're inching their way forward. But I say always, try to get out there and think about it and talk to somebody about it. There are a lot of tools out there even now. I just read something about a site called, is it Trackway? Something like that, where you can go through a set of questions, and then you go seek counsel from somebody like Doug, right? But at least get a sense of where you are and what you could protect or not protect, because it varies. It varies all over the map. With InterDigital, obviously, that was our model, right? But I've seen others that evolve, such as, in Doug's company. I have a small client now who is a consulting firm. But he has created an aura for himself, or a brand for himself, by trademarking various things. And we tried to get patents on one item. And it's very interesting to see the aura. I've gone to conferences with him. And it's clear that most of the people in the industry think his company is much bigger than it is. Just by the aura, the branding, the marketing, the trademarking that he's done. So, it varies, but I'd strongly encourage people to, do the benchmark with either on your own or with people like Doug or others to get a sense of where you can at least get started.
That's interesting about branding yourself, because Warren Buffett said, in the future, what creates value for a successful company? And it's three things: strong balance sheet, strong and flexible management who can move with the change in the economy, and branding yourself. That's the three things that he said makes successful value creation down the road. He knows something about it, I think. Drew, question for you is, we talked about IP strategy and so forth. How did owning IP and the IP strategy affect your operating type decisions on a day-to-day basis on your companies?
I'd mentioned before, I don't think we probably didn't take it as serious as we should have in the beginning, and I agree with Richard's comments that it's probably a good place to be when you know what you're not doing. Even though you're not doing it, just good to know exactly what you're not doing, like where you haven't invested and where you may start to invest. And maybe a step further is what would be the right trigger points for you to start to spend more time on it. I actually think one of the things with IP is it's a big time taker, as well as there's an investment that you have to make to support it, and it's usually the time that makes you avoid probably having or knowing what the field is when you're trying to play it. I had mentioned before, I think we were kind of forced into an IP strategy. Politely, and maybe they weren't a troll, but they were as close to a troll as they probably could have been. We were issuing payments to sales incentive or salespeople across the country: Ford, Toyota, Mazda, Isuzu, Hyundai, GM, and every time they sold a car or a piece of equipment, they would get a payment from us on a prepaid card instead of a check, and this would come directly from the manufacturer. And if I had everyone in here read the patent, well, first of all, you don't fall asleep, but second, if you could determine that you thought that applied to my business, I'd buy you a steak dinner. Regardless, it was determined that it applied to our business and our industry of paying incentives out to salespeople. We slow played it in the beginning, ignoring some letters or knowing that we were slow playing. And at this time we had counsel involved, and they said, let's see what happens. But one major event happened where they got a company in the industry to settle. And at that point, they started to gain a lot more leverage over everyone in the industry, and basically started to ramp up their efforts on us. And what was interesting was it really, in hindsight, it was a negotiation. So, let's say they started at, hey, we're going to take 20% of your revenues and on this particular product, and you're, what would you like to do? And it's a difficult place to be, because you're going to have to end up in a deal with them. It's not at this point. At some point in the process, we realized it wasn't that we were going to avoid this; it was how much we were going to pay. And at a 20% number, and I'm using relatively arbitrary numbers, we would have definitely gone out of business. We'd have lost our second biggest vertical, and it was just too big of a pill to swallow. So we took a very aggressive strategy with the other side of the table, and played a little bit of a chicken and an egg game that said, listen, you can go to every one of our clients, and it's kind of what they wanted to do. They wanted to go to all those big people, and we said, that's fine. Like, you guys should go do that, because now you're bringing Toyota into it, and you're bringing other people into it that are not going to like it. Now, immediately they would have shut us down. They would have said, we'll go back to using checks. It was an easy substitute to eliminate the problem for Toyota or the Dells of the world. But that means no more royalties. So the fight was such that it's not to say I won. It's to say how much money can you get out of the patent that was in front of us. So we sat in front of them. We said, go ahead and do that, which we knew was a zero-sum game for them. Or we said, you want to know what? I'll go to all of my clients and I'll strike a deal with them. and I'll basically get some type of royalty from you, but I'll do it as a consortium. So all of those clients on my book will negotiate on your behalf, and then I'll come back to you with the opportunity that, and you see if you make it or not. At the end of the day, they were always going to push us into a zero-sum game if it wasn't the right deal, just because our balance sheet couldn't take some of the royalties that they wanted to do. We sat down, the CEO, the chief internal counsel, external counsel, and basically devised a strategy that said we're going to extend every single one of these contracts out 5 years, and we're going to get our clients to finance the payments that was due, which ended up being in the neighborhood of like 3% of revenue. I'm not sure if it's the exact number, but it was close to that. There's a big number though, because when you're selling money, 3% of revenue is big, because you're only doing transaction costs, and you got to have this fight over, like, is revenue the money on the card, or is revenue the processing transaction fees that you're doing? So there's a lot of complications in there. But we use it to our advantage because we extended all the contracts out 5 years. So I just put inside of our books 5-year contracts with some of the largest companies, Fortune 500, and they guaranteed us volume on that side. At the end of the day, the client didn't want to give up our product and go back to checks, and they were willing to pay this. And as long as we were willing to work with them on the timing of the payment. Long story short, or to end quickly, it was a negotiation, and we got to a price that they would win. No one was happy. The other side of the table wasn't happy. We were not happy. But we made a little bit of lemonade out of it, because we turned out where we'd go back to our investors, future acquirers, and say, I have a 3-year contract with Citi, I have a 5-year contract with Dell, and those were things that kind of changed our business. But the whole process is somewhat enlightening, and as soon as you feel like you're in the beginning of that track, you should get counsel immediately, even if you think it's a bogus claim, and you should start to think about what are the trigger points of how I'm going to deal with the issue. After that, we were a lot more diligent in just at least understanding, even if no one asked us, where we thought we might be infringing on a patent. But I will tell you, it is I'm a product person at heart. It is nearly impossible to know in today's day and age I think if you're infringing. I mean, it is. I'm also an engineer by trade, so I'm very analytical, and I'll spend hours of time in the patent library online, and I can read that stuff and not fall asleep, maybe better than average, I should say. But after exhaustive search, and even after exhaustive search by attorneys, I've had people show me stuff where I say, yeah, I think that might be an issue. And when we were at a startup, you say, okay, let's just know it's there and let's keep our eye on it. But when you're at Citi, you got to spend time on it, and they want to know, what could we be doing? Do we have a defensive patent against that? And so it takes a lot of time. But it's also a bottomless pit of time. It's not something that you ever get the answer to. And for me, an analytical person, that's a hard kind of thing to swallow. As a CEO of a startup, I think it's something you just live with. As a CEO of a business group within Citi that's large, it's something that you try to fend off how much time you spend on. But we were forced into a patent, or kind of an IP strategy in that case, that we turned into a little bit of lemonade, but it was definitely an eye-opening experience.
Drew, that raises a number of issues. The first of which is, whether you approach intellectual property from an offensive or defensive perspective. And Drew's comment was, "I'll buy you a steak dinner if you can tell me if the product infringes." Well, the problem is that patents, and I'm sure you experienced this firsthand, patents that are issued are presumed valid. So if you want to say that the patent's no good or that you don't infringe, the only way you're going to do that is to go to court, go through 2 years of litigation, pay $2 million, and get to a decision from a judge or a jury. So if you're in a defensive posture and you've got people coming after you and litigating patents, that's really the only recourse you have. And on the other side, and obviously this scales for the size of the business, and the size of your checkbook, I guess. But I was involved in one litigation matter where there was a $500 million public contract coming up for renewal, and one of the two leaders for that contract went out about a year before the contract was up for renewal. They bought 4 patents, and then they sued the other company that was leading for the contract, and that clouded the entire bid of the second company that was bidding for this $500 million contract. And at the end of the day, there was probably a good case on both sides for infringement and non-infringement, but the fact that the other company was put on the defensive, the one that had gone out and bought 4 patents and spent the money to assert them in court, got the $500 million contract. So it may not be fair, it may not be tasteful, but it's a reality, and that offensive versus defensive posture is something that you have to consider. And again, obviously $500 million may be a different scale than some of us are talking about on a day-to-day basis, but it's a reality.
Let's just add to that is, and you can scale this to whatever business you're in about thinking, forward a little bit. Mentioned earlier about Google, and trade secret is the thing, but I'm sure everybody knows that Google paid $12.5 billion for Motorola, right, the handset business, and everybody basically says they paid $12.5 million for patents. Now, Google's not going to be the one at the end of the infringement case, but their clients are, right? So everybody that's using Android, they give it away free. So they can't go after Google. Now, some have tried to pierce through that, but by and large, they can't go after Google. But what did Google recognize? Well, they recognize that if they're not protected, if their clients aren't protected or their customers aren't protected, that their customers may look for a substitute for Android, right? So what did? They went out and bought these patents so that they could, the Samsungs and others who didn't, or others who maybe didn't have, Samsung is a different story, but maybe some of the other people that were making handsets that didn't have such a strong portfolio could come to them and say, hey, I want to borrow one of those to use in litigation. So they paid $12.5 billion. As it turned out, the patents aren't that good that Motorola had. So they were paid. Now compare and contrast that with Microsoft. All right, Microsoft is going to buy Nokia's handset business. Microsoft had a very strong patent portfolio, right? And they are buying the handset business, and Nokia was smart enough to enter into licenses that they could pass through. So now Microsoft is going to end up with a very strong patent position and a very strong margin position because they don't have to spend, money out of their gross margin to pay others for patent licenses. So there's sort of 2 examples of thinking ahead. Google is arguably, one of the most valuable companies in the world and continues that, but they make mistakes too because they didn't think ahead. As far enough ahead, I was actually trying to sell Google some patents for the private equity firm, but they had their view on things, and it took them a while to get there. So those are 2 examples, and you can take that into whatever industry you're in and determine whether or not that exposures like that exist. Right? And there are people out there that can help you analyze that, for which you don't have to spend a lot of money right away because they want to get the business longer term. So.
Yeah, I think the panel makes a great point as far as offensive and defensive and doing things in advance of situations. The big companies can afford, in generally, to litigate and defend their patents. But when you look at the value of assets and the value of the patents, I always laugh because you can insure the life and disability of the key people. You can insure for fire and flood your hard assets. But nobody really is able to, or has in the past been able to get insurance to enforce their patents and their non-competes and their confidentiality agreements and their trade secrets. And so we work with an insurance company that now offers enforcement insurance. So for a premium, it's the Ford wiper blade example, where Ford came in and from the entrepreneur took the intermittent wiper blade patent, and he took him 10 years and ruined his life to try to fight it. if Microsoft comes into one of my $10 million tech companies and signs a non-compete and says, I'm going to look at you to buy you, looks at your information, gets information, steals your customers, your ideas, and leaves and says, you know what, we decided in due diligence we don't want to buy you. Can you fight? Can most companies, $10 million companies, fight them? No. So when we value patents, one of the key things we look at is, do you have the liquidity and the capital to enforce the rights behind that piece of paper? Because if not, it's just a piece of paper. And so what this insurance company will do is, for a premium, they give you $1 million for legal costs that will allow you to enforce your patent, your non-compete agreements, your trade secrets, your confidentiality agreements, trademarks, whatever it is. And now it makes that little guy play like a bigger player. And so, I think, the big guys like to protect it, but they have the money to enforce it. The little guy usually doesn't. And so this is one way to liquidate and have capital to do that. But anyway, moving on to the next question, I guess, Rich, we'll just start with you on, as companies grow from either startup or smaller companies to big companies, whether it's through acquisition or organic, the IP strategy sometimes changes, because when we talk to our clients, I usually tell them, in the early stage, when you're smaller, your patent may be your IP that you're using to grow the business and get funding. But when you sell, it's usually your customer base, your database, your trade secrets, because that patent usually has either run out or it's been re-engineered and doesn't have the value that it used to. So I always tell people the IP you start your business with, it's probably not the IP you're selling when you ultimately exit. So you want to focus on what you're selling, protect that, monetize that, and optimize it, as opposed to the old IP. So as companies grow, and you say, how does the IP strategy change, and do they focus on that change and what kind of IP I'm going to exit with?
I think it's sort of what I talked about earlier. I think as companies grow, they become more sophisticated and learn about that. And there are times when you're left with all you're left with is your patents. But it's obviously in a minority, those that can monetize patents, right? But as you grow your business, you want to think about everything in the context of your value chain. Where are you adding value in the value chain? And do you need to support it with patents? Is your branding important? Is your copyright, your trade secrets? They're all important. And I think over time, as you indicated, yes, if you have a case where you're creating patents continuously, and it depends on where you are, if you're a technology company, you have to continuously evolve and create your patents. Because if not, people will reverse engineer and figure it out on their own, right? And then you lose value. But it's everything collectively, I think, is where people get to, and it really depends on the type of company you are. But sometimes, copyrights, if you're in that area, or trademarks and know-how. I was with a specialty chemical company. We were multinational, probably had 8 patents. Why? Because it was specialty chemical, and it was the recipe, right? Just like Coke, the Coke recipe is sacred. Right. So that's the value of Coke, right? Especially chemical companies, a lot of that is in the recipe as well. So you have to be selective of where you're creating the value and start understanding that. And again, surround yourself with, or you don't have to hire it full time, but try to surround yourself and get to know people that actually have a good perspective on that and can help you evolve that as part of your overall business strategy. It's part of your overall business strategy. Your IP is not a strategy, it's part of your strategy.
That's a good point. Yeah. Doug, in your client base, do you have some examples of where maybe IP either gave somebody a competitive advantage or was actually in some case a barrier to success?
Sure. Well, obviously the story about the $500 million contract is one. Again, this doesn't all exist on the patent front, though. One example is on the trademark front. People don't think about simple things like registering your trademark with the trademark office. And for a company that's under 50 employees, it's $375. It's not much more than that for bigger companies to register a trademark. And that actually gives you rights throughout the United States to the use of your name in your line of business, and you can register for multiple lines of business. I have been involved with one situation where a company that had established itself just didn't get around to registering its trademark. Another company 10 years into the game came along and started using the same name for a very similar type of business, competing with the first company's biggest customer, and this created a nightmare. And the newer company, the younger startup company, actually registered the mark. Because my client's mark was not registered, this registration actually created a big issue where the rights are potentially diminished for the company that's been around for 10 years, despite the fact that this new company is brand new and has done nothing in the marketplace. So, little things like that can go a long way. You could end up changing your name 10 years into the game and losing a significant amount of goodwill because of a small oversight that, hopefully we could take care of for little or no effort. Again, a lot of times in this question we come back to patents. And both Rich and Drew have kind of touched on the idea of saying to competitors in the space, or even to OEM suppliers or OEM suppliers to their customers, you're going to license this from us. And if you have an integral part of your device that requires something that I have a patent on, whether you think it's valid or not, saying I am going to enforce this patent against you unless you license it is a big competitive advantage, and usually leads to a licensing agreement, because giving up 1% or 2% or whatever it is a heck of a lot cheaper than going to litigation, and not just the financial costs of going to litigation, but the fact that your senior executives, your senior engineering people are all distracted for 2 years through discovery, depositions, actual trial, and it's a major competitive advantage if you have that piece that your customers need.
That's a great point, because after we settled, we got more business because everyone knew this was going through the industry, in the example that I said. And there's probably, arguably 40 people were providing a similar product. But as soon as the first settlement happened and a few others, everyone was said, which side of the line are you on? Like, have you solved this problem or have you not? And after we had a surety of it, while we weren't happy with it, we were on the right side of the line, and we actually won more business. Not only did we extend contracts, but we won more business. I think there's some lessons in our acquisition with Citi that I look back on that were important to Citi when they happened. One was, I mentioned we had co-branded cards. So while the eCount brand meant nothing to Citi, what we did establish, though, was a pattern that we could co-brand. And in order to establish that pattern, we had to protect the name eCount, and we wanted to use it in all the different places. So once we got to the point to sell to Citi, they said, there's 1 million cards a month to Verizon, and my brand is going to be on there. It's not going to be eCount anymore, it's going to be Citi. And they're issuing 15,000 cards to all the Toyota salespeople in the country. And my brand's going to be on there, Citi, not eCount. So I would have never been able to keep my brand on there unless I was trying to protect it, during the first 7 years of our company. I think the other thing that the IP strategy did towards the end, it was a sign of sophistication to Citi. So it said, these guys are buttoned up. We had lots of questions in that area, but it let us project that said, hey, the management team is serious about this. And then the last, we had 2 patents and 1 pending when we were acquired, and they did look at them as risk management within the industry. So I think that all those things were contributory to the value that we were able to either protect or get from Citi on our sale.
Very good. Yeah, I mean, I'm a big fan of using a competitive advantage when you can, sort of having the hammer and using it when you need to. We had a client, they manufactured a product. One of their biggest competitors was a Japanese public company worldwide. My client had multiple service product lines. One was a formula for a product that the Japanese company kept trying to replicate and could not. So after years, came to my client saying, we'd like to, do a license agreement. So what we said was, that's fine. We'll do a license agreement for this one product, but you cannot sell in the U.S. for 10 years for that product. So my client then sold in 5 years, which is always nice. But again, taking advantage, taking a step back, seeing when do you have that competitive advantage? How can you use some of that IP to negotiate a better deal for yourself in the right situation? And many times companies don't realize they have that leverage until after the fact. So taking a step back and saying, if I'm in a position like that, what can I get for that, and take advantage of it? So all good points by the panel.
Well, and Bob, some of that
Yeah.
may be a market effect too. As simple as if you have two young companies and one of them, let's say each of them has a product line with 3 products that compete head to head, and one of the companies goes and gets a registered trademark on each of those 3 products in the product line, markets those under those 3 registered marks. There's really possibly no difference in the products whatsoever. It's essentially a marketing approach and a branding, a brand strategy that costs you little money and may actually have you perceived as a more mature business in the marketplace.
That's a very good point. Excellent. Switch to a little bit of due diligence on IP for acquisition of IP. Doug, in your client base, when clients are buying intellectual property patents and portfolios, and then Rich, maybe you can follow up on it, who gets involved from the company generally? Is it more the technical people? Is it more the legal team? Is it everybody? Who comes in first? How do you negotiate? Some examples of sort of how clients have, gone after and purchased or acquired patents or IP.
So if we're on the buy side, it's obviously going to have to start with the high-level decision makers at the strategy level. And obviously they will have consulted with their technical people or whatever type of business it is, the people that need to inform them. But the decision's going to come from the high-level strategy people, and they're going to say, we've got this target, let's look at it as a possible acquisition. At that point, you'll get legal involved, people like me, maybe even just general litigation and corporate attorneys who will look at, where's this IP been? Has it been litigated? Let's look into the prosecution history, which is just a fancy term for all of the back and forth that's gone on in the process of getting these patents. It becomes very, very legal heavy at that point, but through the process we'll consult with technical people on the client side, so on the buy side, we'll say, what is it that we're looking for, what are we expecting to see, and we'll try to be in touch with the technical people on the seller's side, mostly if the inventors are still there. If it's stuff that they bought, we may or may not be able to get in touch with the technical people on the sell side, but we'll be really interested to know what they think they have, how this came about. What was the process in developing and protecting this IP? What did you know before you protected this IP? Which, some of these questions vary a little bit now depending on when patents were issued, because the laws in the United States changed a year ago, September of 2012. We were the last country in the world to be a first to invent country. If you could show that you invented something first, even though someone else filed the patent, you could still invalidate that patent. Now, we're in line with every other country in the world after September 2012, so it's a race to the patent office. If you didn't patent it first, you didn't do it first. So, anything prior to that date, inventor notebooks are important, concurrent notes of any kind are important, and it's just a long way of saying that we will get directly involved with the technical staff if possible. And then, it circles back to internal legal and the decision makers at whatever the highest level is that needs to make that decision on the client side, whether to buy or pass.
Rich, on the due diligence side.
It depends which side you're on.
Yeah.
If you're on the buy side, I was fortunate because of our strategy we would articulate and know where we wanted to fill in some holes. And I had somebody that handled corporate development for me. He's now my partner. And he would work with a group of the technical people in the company, so to identify areas where we would be looking for patents, and then make contact, and then have some of our technical people actually look and do some of the stuff that you might pay Doug to do, because we had those people in-house, and then we would go outside for that. On the buy side, you know, it really depends. Are you buying for defensive purposes? If you're buying for defensive purposes, again, you have to know where your holes are, and then you have to really be clear on getting the right technical help to analyze those patents. If you're buying to be offensive, and that's to monetize, and you can call it patent trolls or whatever you want, it's, you know, as I mentioned earlier, it really comes down to, can it withstand litigation? So, you know, you want to be able to look at patents and do a fancy thing called claim charts, which is basically demonstrate infringement. And, you know, if you're in that game and people are bringing patents to you, for example, if they haven't done claim charts, nowadays people just ignore.
Right.
Say, come back to me when you have claim charts, which says, this company's infringing, here you are, go ahead and take this and go after him. So it's a little bit, you know, across the board, but, you know, just to show you how the landscape changes, I have an article, it's called Landscape 2013, who are the players in the IP marketplace? And they break it down. This group, I thought they get a little carried away, but they broke the groups of people who are in dealing with IP into the numbers now up to 19. From patent licensing and enforcement companies, trolls, to IP insurance carriers. There's 19 different types of groups that they've listed here and what they do. So there are those that, for defensive purposes, just buy up and aggregate patents. Right? So if there are groups of competitors that say, I'm tired of getting sued, there's companies out there like a company called RPX, right, which actually goes out and buys patents and gives, you know, takes them off the market as opposed to being offensive. They take them off the market, and, you know, anybody who participates in that buy is actually covered. Right. Then there are those companies like a local company in Bala called Rembrandt that is very much I buy, it's got to be really good, I'm going to litigate. Okay. So it depends on your business model. But if you're just have your own business and you're looking to buy, right, you want to be buying for defensive purposes if you're a product company, so you want to find a way to protect yourself. You know, because if you're sitting there naked, like Doug's company was for a while, chances are somebody's going to come after you if the market is attractive enough and they see you as a business opportunity.
Good. Drew, on just talking about R&D projects and so forth, how do entrepreneurs generally evaluate which R&D projects to pursue to create the most value?
I mean, I personally, in the companies that we look at, we always look at the market. So what's the problem in the market and how big is it? And what is your widget to solve it? And then that's where we're going to prioritize. I would say that you know, I deal more in a software realm than a hardware or tangible good realm, and I think more and more I question whether patents are valuable in this realm. I think if you have something that's truly unique, you should be considering a patent. But if it's most things that I look at as a patent, you can quickly re-engineer around that and solve the business objective to get access to that market. Now, if it was a hard good and you had something that was truly unique, then I think it's a lot. I personally would feel more comfortable, you know, going down a protection route. You know, it's funny in the venture community, a lot of people are saying adoption is the new protected, you know, the way to protect an idea. You know, it's who can get to 100,000 X or 1,000,000 X, and that's how you protect your idea more so, or that's when you start to think about protecting it. I still think you have to have a playbook on protection and IP in those cases, but the business method patents and some of those things are more and more I'm seeing kind of called into question on whether to invest and pursue those aggressively very early on before you've even identified a market that has value. So from an R&D perspective, we're very, I'm always looking for companies, and my personal pursuits is where is the market the biggest. I think actually this is where most companies fall down, is they don't prioritize market size and how to attack and the problem within the market. Most of them focus on product and not the problem. And it's in those cases where they, IP might even be a distraction because you're trying to protect a product that doesn't even have a market that, is proven. You might do a great job of protecting something but it has no value because when you go show it to the market, they say, I want something else. And I think that's kind of why some in the community are saying, let's wait until someone has the 100 or 10 or whatever the right metric is of adoption before we think about protection or anything like that.
Right. And Rich, just on valuation, which is critical for any investors or buyers, you obviously, through your experience, have bought a lot of IP and things of that nature. What do buyers generally or investors look for in an IP portfolio? And is it different between a financial buyer, a private equity fund, or a strategic buyer?
I think it's very different
Yeah.
between if you're financial or strategic. If you're financial, your goal is to optimize or monetize, right? So as I mentioned earlier, you want to make sure that those things that you buy, primarily patents, are very much enforceable, that will stand the rigor of litigation, because you have to be willing to litigate. And if you're not willing to do that, you're not going to be in that business. Whereas if it's strategic and you're looking to position yourself, you're looking for things that will allow you to defend against those. So sometimes you're in the offensive mode, sometimes you're in the defensive mode. I'd just like to follow up on Doug's comment, the last
Sure.
one. In terms of R&D, I always, as a CFO, I always said, look, let's think of R&D as it links to our strategy, the attractiveness of the market, and the IP strategy follows. How do you protect it? How do you understand it? But I always said, think of R&D as a series of options, right? So where's my first decision point? Where's my second decision point? There's fancy terms called real options that you can use, but it's really a series of options, right? Because no offense to the engineers in the audience, but every engineer, especially if you're in the, every engineer that's a triple E wants to do a chip, right? But I would always say, all right, wait a minute, we have to get to the decision points. Where can we prove the technology, et cetera? So it was a series of options that we had them think about. On the VC side, there's a little bit of, I'll give you my jaded view of it. They're a little bipolar in that regard, right? Because the VCs on the one hand will say, don't worry about it. But, when things start going south, they're saying, why didn't you get that patent? Why didn't you get that patent? It's sort of like drive sales. Oh, we're running out of money. Okay, cash flow. So I think you have to balance that, right? Because, it depends on the economic cycle we're in as to where the VC's heads are. And what their model is and what they're willing to accept.
Do you think it's different by industry, whether it's telecommunication, technology, like Drew's company, life science, or the way buyers approach and look at the portfolio? Or not really? Is it just monetizing it and that's it?
No, I think you're going to look to the most attractive market in order to monetize.
Right.
So that's why the wireless world is so popular these days, because so many handsets are sold.
Right.
So it really is the attractiveness of the market and how you can monetize things.
And Doug, do you see any difference in documentation and protection of IP among industries? Is one doing more? I know Drew made the comment similar to what I said early on that maybe in technology there's less patent and more trade secret maybe to try to protect. Do you see trends among manufacturing of products, service businesses, tech, life science, consumer products?
Night and day. If you're talking about a software company, I think, Drew, it was you who said, you could get a patent in, 3, 4, 5 years, and your technology is so outmoded at that point, and it's changed 6 times in the 3 or 4 years that it took you to get the patent, and you may be getting a business method patent whose value is in question, not only because I can engineer around it, but also because the judicial landscape keeps changing with every new decision that comes out from the Federal Circuit and the Supreme Court about software and business method patents. On the other hand, if you are a pharmaceutical company, I mean that patent is worth 1,000 million times its weight in gold. You know, I mean the model for these pharmaceutical companies is to come up with 100 new drugs, patent each one of them, patent the molecular structure of the active ingredient. And when one of your 100 hits, I mean, that's your billion-dollar product. So, and there's everything in between. There's all kinds of life sciences companies. There are hard product companies. But yeah, there's a vast difference in the type of industry. And, to answer the second part of your question, I think that the software industry is starting to get wise to the trade secret route. And it's very important. The most important thing in the trade secret world is documentation. And documentation of the policy as much as the trade secret itself. Documentation of the enforcement of the policy and documentation of the policy and the secret itself.
And I'll start off, Rich, with you. Just on talking about leveraging and monetizing IP, which ultimately is the end result for everybody, right? That's where they want to get to. And we all know you can sell your company, you can sell the IP package, a portfolio. You can license your technology, bring in a continual revenue stream through the royalty. You may be able to borrow against it. From monetizing it, when you look at your portfolios and you want to monetize it, how do you go through the various options? And maybe there's other ones I didn't mention, but the various options and kind of narrow it down to the one that makes the most sense for your various companies you consult with.
I think by and large, most, I'm asking what business do you want to be in? Because, the goal is to figure out the best strategy in order to execute what you're trying to do. And, if they have IP assets that are already in existence, I'll say we have to take a look at these IP assets. One, to determine, do they support your goal as a company? Two, let's look at your strategy. Is your strategy, are you really trying to do something that you can't do, right? So I'll use the example of everybody wants to get into the chip business, but I can tell you the number when you become a semiconductor, player. They're usually sold for $150 to $250 million. That's not a perfect science, but I used to sit with enough engineers to say, I want to make this chip, and I'd say, okay, what's the market we're going into, and who are the other players? Well, I want to go down Main Street. I want to compete against Qualcomm. Oh, you do? All right, so how often does this chip change over? So what we'd end up with is I'd say, okay, here's the model, you fill it in and tell me what the value is. And then I'd say, okay, now let's look at the intellectual property you're creating from that. Can we monetize it in a different way? And can we make the revenue stream longer and create something that's worth more than $150 million? So those were sort of the balances that we would get to. Then there's the whole issue of, have you created something as a byproduct even, or something you used to do? There are a number of companies that change business models. Well, they still have valuable assets. Mm-hmm. So probably the best thing to do there is, so that you're not distracting, is hire somebody, outsource that, sell it, share in that. Right? I've one client who's in the medical industry, actually does testing for a lot of pharma companies, but his team developed a method of doing something and created patents, and they're at the FDA. He looked up one day and figured out, basically viscerally, not through any analysis, but he's a good business person. Viscerally, he knows that his business is worth more. This new business has the more potential value than the old business, which is doing testing for the pharmaceutical industry, which everybody's starting to do that now. Right? So again, thinking about or really understanding of what your strategy is, and then if opportunities present themselves, make sure you're open to how you monetize those opportunities. Because if you're doing, I would always encourage people to look and say, can I monetize by licensing the patents and the know-how? And, you know, getting there quicker, a little bit more low risk. Somebody else takes the commercial aspect of, you know, monetizing things when it comes to building inventory, et cetera, especially when you're in spaces where you're competing with much larger, much more deep-pocketed companies.
Yeah, I had a manufacturer that kind of did a little bit of both. They were in the Mid-Atlantic states. They wanted to grow nationally, but they didn't have the money for that. So what they did was they went to 3 large corporations around the country, broke the rest of the country into 3 geographic segments, licensed to them to grow in those regions, get a royalty from there, but they kept the Mid-Atlantic states to continue to do their R&D on their products, develop products, sell the products, and service their products. So it's kind of an interesting play, kind of a mix of both, and it was a way to grow with other people's money type thing. Doug, on that vein, from a documentation standpoint, depending on what kind of monetization there is, right, selling versus licensing and so forth, I assume there's significant legal issues and so forth, differences that you would counsel clients on.
In the development of that?
In a monetization, like in whether it's a sale, whether it's a royalty, helping consult, helping them make that decision, but also helping protect them in a transaction, whether it's a royalty transaction, a sale transaction, a
Sure.
lending transaction.
Sure, and if the royalty stream is there and you can license that IP, I mean, obviously that's the best way to go. You continue to own that asset and derive revenue from that asset throughout its life. Selling it, you're obviously going to have the instant influx of cash, and you may be able to do other things with that. But yeah, there are all kinds of issues when you get into any kind of licensing deal or partnership with someone. Are you going to be able to reverse engineer this IP? What comes along with the actual patents that I'm licensing to you? Do I have to impart some know-how to you from my people to let you implement this intellectual property that may be documented in a patent? Is there maybe some trade secret that goes along with that I'm teaching to your people that could be a competitive advantage to you if our deal ever ends or goes south, or however this may come to a conclusion? So there are definite issues there. There's the obvious issue of if I sue you, or if I sell you a patent, you're not going to sue me with the same patent that I just sold you, which, if you failed to put that in your agreement, I wouldn't be surprised if it happened to someone on occasion. I wouldn't be surprised if their lawyer got sued afterwards, too. But, so yeah, I mean, things like that definitely creep up, and, that's why people hire professional paranoids like us to dot the I's and cross the T's in the transaction itself.
Rich, just a question. One of them is to borrow against the intellectual property, right? And banks tend to not like to lend on intellectual property. They'll lend on cash flow and hard assets, but not necessarily collateral as intellectual property. And in your experience, I'd like to see if you've seen much of that or a trend. We're seeing a little bit of a trend where they are willing to do. We just did a valuation. Clients bought 4 consumer product brands out of Big Pharma, and they outsource everything. So, one of them was $70 million with 12 people, full-time equivalents. Not a bad ratio, right? And one was about $10 million, right? And what they did was, we work with about 85 consumer product companies, but in these 2 examples, they outsourced everything: the manufacturing, the warehouse, the pick and pack, the freight, the accounting, the sales and marketing, the payroll. They had very few people. What they owned is that brand, which is all that really has any value anyway. And so we were able to we valued it, but we were actually hired by the bank as opposed to the company in this case. They became a client after the deal closed, but the bank hired us to value the brand, and then they lent 50 cents on the 50% loan to value on the value of the brands because there were no hard assets. And so, yeah, the cash flow backed it up, but it was interesting play where a lot of banks are very reluctant unless you have some hard assets, some collateral, some personal guarantees, to step in. Are you seeing any trend where banks are senior lenders now, not mezz guys or sub debt, but senior lenders are willing to do that on any consistent basis?
I haven't been exposed to
Okay.
much of that. There are intermediaries who will
Right.
sort of take some of the burden
Right.
off the banks
Yeah.
to step in, but I haven't seen too many banks
Yeah.
that want to be that creative
Right.
these days.
It helps if you have a portfolio of it. The more you have, the more diversified. But I mean, the famous one is right, David Bowie or whatever. He took his music royalty stream, bundled it, securitized it, and borrowed $40 million against it. So I mean, it's that kind of idea, but to a smaller level. But
Bottom line is
yeah,
you have to have some demonstrable cash flows to back that
To
up.
back that up,
Or
correct.
banks are not going to lend.
exactly. Yeah. Well, these are old brands, so
Right.
they had history. Right. Exactly. Just curious. The last question we'll wrap up with is really just if anybody any war stories or situations where you might say either in consulting or Drew and you're both sides, right? You invest in companies, but you also own companies. Any war stories on the IP, negotiating deals, or anything of that nature that you want to leave the audience with. I'll start with whoever wants to take that one.
And maybe this is a question more so than an answer, but I more and more I think that intellectual property is not driving innovation the way we manage it in the landscape or the environment that we're inventing in. The laws of intellectual property are not driving the right innovation, because when I kind of draw the line, the person who does all the work and creates all the value usually doesn't have the size to protect properly their intellectual property. And the person who owns a great intellectual property strategy or distribution where they can apply it and win quickly can extract a lot of the return out of the guy who kind of carried it across the goal line and made a lot of, or realized a lot of value. So it's a hard topic for me to talk about, because there's no fix. It's not like you're going to wake up and fix it at the end of the day. But I think you got to realize if that's the environment you're in. When you read Eric Ries's Lean Startup book and he says, hey, iterate, and do a little bit better and a little bit better and a little bit better. Well, sooner or later you got 1 million people, and maybe you didn't think about IP the right way, and now Intel thinks you did something that they did, and it's impossible, even though you reached a great level of success from where you started. And I'm not so sure the spirit of kind of like fostering innovation is weaved through IP strategy. So I'm speaking purely from an entrepreneur's side. And I'd love to hear you guys comment. I think we're a little bit broken in how we manage, and I'm saying in the U.S. level, on how we foster innovation, and the IP laws maybe getting in the way of that for us.
That's a really interesting point, and again, I think really illustrates the distinction between different industries. Being a software guy, I see a lot of software patents where I sit there and I go, come on, we did that with just Java code in 1998. This is silly. This shouldn't be a patent. The fact of the matter is, once the patent is issued, it's valid, or presumed valid. So there definitely is a different a different perspective on this across different industries. If you invent a new pharmaceutical drug, a new molecule, you can be pretty sure that it hasn't been done before if it hasn't been done before. So I think there, like we discussed earlier, there really is that difference across industries. And the purpose of intellectual property, the patents are right there in the Constitution, to promote the progress of useful arts and sciences. So is it doing that? I think that if you brought 50 IP practitioners into this room, it would turn into a heated debate. Very heated debate. People who talk about patent trolls and others who get offended by that term and call them non-practicing entities or patent enforcement entities. It's a big question. I do think that in the software world, the patent the patent process is broken. I agree with that. I think outside of the software world, it functions a little better. Unfortunately, we have to operate in the process that we have. So, the question was kind of, war stories, horror stories, battle scars. I mean, that's the real thing, is just knowing when to we have to tuck our principles away for a little bit and operate in the paradigm that exists. And, if we don't protect the things that are most important to us in that landscape, somebody else is going to go do it and possibly come after us. And I've seen that time and time again. And it's hard to figure out for small companies what the right time is, but there's a time and size for every company. So it can be worked within the rules the way that they stand for any company today. And maybe one day the Supreme Court, the Federal Circuit, and Congress will all get in the same page. But until then, it is what it is.
No, I get it.
I won't go through specific war stories, but I guess I would comment is you just can't, nowadays, you can't stick your head in the sand and ignore it. It's that simple. Over the last 10 to 15 years, the level of focus and sophistication of all the parties has ratcheted up demonstrably, right? Whether you're in-house or whether you're attacking, right? Everybody has ratcheted up, right? The head of IP for Ericsson reports directly to CEO. Why? Because he creates $1 billion a year in revenue. That's high profit. Okay. And then you go into, when Apple, before they were starting, making the iPhone, they had a plan. They had determined where they might have the largest exposure, and they went to those parties in advance. That was pretty good. Okay. And the spectrum is all in between. I read off there's 19. I might group them differently, but that shows you that people are viewing this space as opportunities to make money somewhere in the value chain. Okay, and don't think that if you're running your own business and you're just keeping making your products or whatever, that you're not possibly on somebody's radar screen. If you're in the right spot in the value chain, you are. So, I would encourage you, just don't put your head in the sand around this stuff. And, learn it a little bit, get to know people who know it, so that you can make it part of just risk exposure, if that's the part that it takes. It's a part of enterprise risk management for your company. Whether it's offensive or defensive, you have to think.
Yeah, no, I think that's an excellent closing point. I mean, it's hard to protect and optimize after the fact. So by putting your head in the sand and not knowing what your real asset is and what drives the value, what's the value creator for your business, it's probably IP. You better make sure you take care of it early on. That's the final question for our panel. Any questions or comments or anything from the audience? Okay. Mike.
I have a question. When it comes to patents, it seems like you have to define the claims in such a detail that it almost gets to be ridiculous. And at what point in time is the claim a valid claim? I know one of my patents was violated by the Chinese. We ended up in federal court in Philadelphia for a week. And it was sort of ridiculous because you could actually take parts out of their product and put it in my product and they would fit perfectly. I mean, parts that weren't purchased parts, these were custom parts which were designed to make the patent work. And it all boiled down to, at the end of the day, a gear versus a lever arm. Okay? And the guy said, well, ours is a lever arm, but a gear is a lever arm. And this argument went on for hours and hours. And it gets to the point like it's almost impossible to protect your product with a patent because a lot of people, and especially this Chinese company, they didn't even have an engineering department. They actually called it a re-engineering department. Basically, what they did.
They're honest.
Yeah,
You got to give them that.
they couldn't explain how the product worked, but they can explain, all the parts in it. But they couldn't explain how it worked, the theory behind it, because all they did was copied it. And their attitude at the end of the day was, well, we had a good run. We sold the product for a couple of years, we, competed with you, and now we have to cease and desist. And, and we end up with a $750,000 legal fee to protect something that, that really I felt the courts should have really hammered the Chinese competition for allowing them to come in and do it. So, it seems like patents, to a large degree, you have to say, what is the value of a patent? And not only the value of the patent once you have it, but the cost of acquiring it.
So, if I sat here and said, okay, let's think of, for the last 230 years or whatever it is since the patent office has been around, let's think of the number of innovations that have totally shifted the paradigm in the world. I would bet that we could probably come up with about 20 if we sat here for about 5 minutes. The microchip, the transistor, penicillin, things like that. There are 8.5 million issued patents in that time. Okay, so we are a culture of improvement. We're a legal and technological culture of incremental innovation and improvement. Some of those increments are bigger and or more valuable than others, for sure. The legal system's not perfect. There's no question about that. $750,000 is a pretty good deal, unfortunately, in patent litigation these days. And I say that with a smirk, but it's an unfortunate reality. It ain't cheap. There's definitely a case-by-case valuation that has to go on of not only enforcing a patent, but it's kind of like a car. What's the cost of ownership over the lifetime of the car? If work and money and resources have to go into licensing this, maintaining it, enforcing it, incrementally improving upon that, constantly studying what came before it to see what the real breadth and depth of this patent are. That's all part of the analysis, and it's a complex thing to do, and hopefully a lot of that goes on up front in the process of getting the patent. And different people have different strategies for that. Some people only patent things where they do that study and they see significant value or significant demonstrable improvement in that increment. Companies like IBM shoot for 3,000 patents a year. There's different ways of approaching that, but unfortunately, none of us is probably going to fix the legal system itself, but we can do our best to really not only write the best patents and get the best patents, but work with the engineers and the management of companies to develop sort of innovation strategies that focus on and target the most valuable spots in that innovation space.
And Mike, you're right. What's the value of a patent? If people can do that, but it really comes down to that documentation and the enforceability of it. And that's why there's actually businesses that help people get liquid to enforce it for that reason. People, it happens all the time. You got to enforce the rights that you have, and there's agreements, unfortunately. But like Doug said, that is the system that we have to work with right now. Any other questions? Yes.
Question. One of you used the example of the David of Goliath. You're a small chip maker, and Intel comes in, you make an agreement with them, you do business, and they, after 6 months, say, you know what, we're just going to copy it and leave you alone. We're a small company, but our customers are the big company. What value is all this IP if that's what's going to happen?
That's exactly the point that I think I may have made the point, but But that's why there's insurance companies now, they provide enforcement insurance, so that you would have, let's say in my example.
But again, that's another major expense.
Yeah, I mean, trust me, it's not as much as the legal cost by any stretch. But I think their premium's like $25,000 for $1 million of coverage. And so, yes, it may cost $2 million, as was quoted earlier, to do an average, $2 to $3 million in IP litigation.
But there's basically nothing you can
But you got
do.
$1 million.
There's nothing
So,
you can do to stop the Goliaths from doing that.
yeah, from a prevention standpoint, I mean, people are going to do what happened to Mike, and then it's the ball's in your court to enforce it or not enforce it or work with it. As even Drew said, there were some that he knew were infringing and he just kind of let it go for a while. That's a business decision. That's exactly right.
But if you
Any
have,
comments?
and if you have, sorry, if you have, that good a case against, a defendant of that size, you're going to find either someone to invest in your case or a firm to take it on contingent fee. I mean, there's no question in my mind you can get that case brought.
Mm-hmm.
I mean, it definitely a part of our decisions in investing is, can you beat them at their own game? So totally get that someone stole your idea, but can we out execute, or is ours truly better? But a lot of times it's a challenge because Intel has way better distribution than you do. And as soon as they inject that idea into their distribution, now it's worth them fighting for. So, I mean, this is where it's, I have like this fundamental issue, which I'm not going to change, obviously, but I think that the kind of risk reward within the patent landscape is not in favor of the inventor. It's in favor of distribution and dollars and attorneys, unfortunately. And the attorneys are just the what's wielding the distribution dollars. And I should say that I think 80%, maybe even 99% of the market works well. But all it takes is one person. It's analogous to me. I invented payment products. 80% of my time developing a payment product was so I didn't get robbed by the Russian mob. I could handle denial of service tax. I mean, stuff that the client does not pay for. But it was just, I had to do it. Every day, our systems were getting pinged by people that were not my customer. And they were not there to just check us out. They were there to grab money. So, at the end of the day, a lot of our time on the product side was spent on security and that type of thing. And I think it's analogous to this business where you have to spend a lot of time on that to protect your assets. Or it's just an input to a business decision that says, you want to know what? Even if I got to I put it in tiers, million, 10 million, 100 million, billion. Listen, I got $1 billion idea here. I should start my plan now. Or I got a $10 million idea here. You know what? I'm going to beat him at the game, and if I get hit, I get hit. That's the risk I was taking.
And I think also you can support your patent in other IP. I mean, we have clients that patents that they've been infringed upon, but they haven't been hit as bad, or they're off patent already now, and they haven't been hit because they built up a database, a client base, other trade secrets that support that patent. So now the value of the business and the value of that patent is also supported. They didn't lose that client base just because somebody else has the same formula as you have. In fact, some of them, we have clients where they have on a consumer product, they have the same exact formula. You read the box, it's the exact same formula, 10% cheaper. My client still is growing at 5% a year. So they haven't gone back, they haven't decayed their customer base. They've maintained it and actually grown it even with the competition. So building that IP portfolio, that's what I'm saying. You may start with a patent, but you want to build around that going concern all of your IP. With that, we're going to have to end. I thank the panelists, and more importantly, I thank everybody here for your time and attention and great questions. Thank you very much.